Welcome to Law Logical. Today's topic is both complex and crucial: private international law in insolvency. This area of law provides a roadmap for resolving cross-border insolvency cases. These cases can involve businesses, individuals, and assets spread across multiple countries. Insolvency, in simple terms, is the inability of a debtor to pay their debts when they become due. This universal issue becomes significantly more complicated when a debtor has assets or creditors in different countries. This is where private international law steps in, providing a framework for courts and practitioners to navigate these complexities. Understanding private international law in insolvency is essential for anyone involved in international business. It is equally relevant for individuals with assets or debts in multiple jurisdictions. This article aims to demystify this complex area of law. It will provide a clear and concise overview for a general audience. Join us as we delve into the intricacies of private international law in insolvency. Insolvency, even within a single jurisdiction, can be a complex process. It involves various stakeholders, legal frameworks, and often conflicting interests. Now, imagine adding an international dimension. Suddenly, the labyrinth becomes significantly more intricate. Cross-border insolvency throws up a unique set of challenges. These can include determining the applicable law, identifying the competent court, and ensuring the equitable distribution of assets. Without a clear set of rules, creditors might rush to different jurisdictions to assert their claims, leading to confusion and unfair outcomes. This is where private international law comes into play. It provides a set of rules that national courts use to determine which country's laws apply in a cross-border insolvency case. It also addresses issues like the recognition of foreign insolvency proceedings and the enforcement of foreign judgments. The goal is to create a predictable and fair system for resolving cross-border insolvency cases. This ensures that creditors' rights are protected while maximizing the value of the insolvent debtor's estate for distribution. Private international law, also known as conflict of laws, acts as a bridge between different legal systems. In the context of insolvency, it helps answer crucial questions. Which court has jurisdiction to hear the case? Which country's insolvency law will apply? How will judgments and orders issued in one country be recognized and enforced in another? The answers to these questions can significantly impact the outcome of a cross-border insolvency case. For instance, insolvency laws can vary greatly from one country to another. Some jurisdictions may favor the debtor's rehabilitation, while others might prioritize the creditor's right to repayment. Private international law assists in navigating these differences. It provides a framework for courts and practitioners to determine the applicable law. This promotes predictability and legal certainty for all stakeholders involved. By harmonizing the approach to cross-border insolvency, private international law aims to ensure fairness and efficiency. This benefits both debtors and creditors while promoting confidence in international trade and investment. Several international instruments provide guidance on navigating the complexities of cross-border insolvency. These instruments, often in the form of treaties or model laws, offer a framework for cooperation and coordination among countries. One of the most significant instruments is the UNCITRAL Model Law on Cross-Border Insolvency, Model Law. Adopted by the United Nations Commission on International Trade Law, UNCITRAL, in 1997, the model law provides a comprehensive framework for dealing with cross-border insolvency cases. The model law has been adopted by numerous countries around the world, either directly or as inspiration for domestic legislation. It promotes cooperation between courts and insolvency practitioners across borders. It also provides mechanisms for recognizing and enforcing foreign insolvency proceedings. In addition to the model law, regional instruments like the European Union Insolvency Regulation play a crucial role. These instruments provide specific rules and procedures for dealing with cross-border insolvency within a particular region. The UNCITRAL Model Law stands as a beacon of harmonization in the field of cross-border insolvency. Its primary objective is to promote cooperation between courts and insolvency practitioners across jurisdictions. It achieves this by establishing a framework for recognizing and enforcing foreign insolvency proceedings. The model law recognizes two main types of insolvency proceedings: main proceedings and foreign proceedings. Main proceedings are those opened in the country where the debtor has its center of main interests, commonly referred to as comi. Foreign proceedings, on the other hand, are those opened in a country other than the comi. One of the key features of the model law is its principle of modified universalism. This principle encourages courts to recognize foreign insolvency proceedings as the primary mechanism for resolving cross-border insolvency cases. It also provides for the granting of relief in the recognizing jurisdiction to support the foreign proceedings. By promoting cooperation and recognition of foreign proceedings, the model law aims to maximize the value of the debtor's estate and ensure the equitable treatment of creditors. It provides a practical and efficient framework for resolving cross-border insolvency cases, fostering confidence in international trade and investment. The European Union, or EU, has taken a proactive approach to harmonizing insolvency law within its member states. The EU Insolvency Regulation, adopted in 2000 and subsequently amended, provides a comprehensive framework for dealing with cross-border insolvency cases within the EU. The regulation aims to avoid forum shopping and ensure that insolvency proceedings are conducted in the jurisdiction most closely connected to the debtor. It establishes rules for determining the competent court, recognizing and enforcing judgments, and coordinating proceedings in different member states. A key feature of the EU Insolvency Regulation is the principle of automatic recognition. This means that a judgment opening insolvency proceedings in one member state is automatically recognized in all other member states. This eliminates the need for separate recognition proceedings, simplifying the process and reducing costs. The EU's harmonized approach to insolvency law has created a more predictable and efficient system for resolving cross-border insolvency cases within the EU. This benefits both debtors and creditors and contributes to the smooth functioning of the single market. To understand how these international instruments work in practice, let's consider a hypothetical scenario. Imagine a company called Global Tech, incorporated in country A with its headquarters and main operations in country B. Global Tech also has subsidiaries and assets in countries C and D. Unfortunately, Global Tech faces financial difficulties and is declared insolvent by a court in country B, where its comi is located. This triggers the application of either the UNCITRAL model law or a similar instrument adopted by the countries involved. Under these instruments, the insolvency proceedings initiated in country B would likely be recognized in countries A, C, and D. This recognition would allow the insolvency practitioner appointed in country B to collect Global Tech's assets located in those countries. The aim is to preserve the value of the insolvent estate and ensure a fair distribution among creditors. This example illustrates how private international law, through instruments like the model law, provides a framework for managing complex cross-border insolvency cases. It ensures a coordinated approach, prevents conflicting judgments, and protects the interests of all stakeholders involved. The complexities of private international law in insolvency have significant implications for businesses and individuals operating globally. For businesses engaged in international trade, understanding these laws is crucial for managing risks and ensuring the continuity of operations in case of financial distress. Businesses need to be aware of the different insolvency regimes in the countries where they operate and how these regimes might impact their rights and obligations in a cross-border insolvency scenario. Failure to navigate these legal complexities can result in costly delays, legal disputes, and ultimately jeopardizing the business's survival. Similarly, individuals with assets or interests in multiple countries need to be cognizant of the implications of private international law on their personal finances. This is particularly relevant for individuals with investments, property, or business interests abroad. Understanding how private international law applies in a cross-border insolvency situation can help individuals protect their assets, avoid unnecessary legal complications, and ensure a smoother resolution process. Seeking expert advice on these matters is crucial for both businesses and individuals operating in an increasingly interconnected world. While significant progress has been made in harmonizing international insolvency law, challenges remain. Not all countries have adopted the UNCITRAL model law, and differences in interpretation and application persist. This can lead to uncertainty and legal disputes, particularly in complex cases involving multiple jurisdictions. To further strengthen the framework for cross-border insolvency, greater cooperation and coordination among countries are essential. This includes promoting the wider adoption of the model law and other international instruments, as well as fostering dialogue and collaboration between courts and practitioners across borders. Technology can also play a significant role in streamlining cross-border insolvency proceedings. Online platforms and digital tools can facilitate communication, information sharing, and the coordination of legal processes, making the resolution of cross-border insolvency cases more efficient and cost-effective. The ongoing evolution of international trade and commerce demands a robust and adaptable framework for resolving cross-border insolvency cases. Continued efforts towards harmonization, cooperation, and innovation are crucial to ensure fairness, predictability, and confidence in the global economy. Private international law plays a vital role in navigating the complexities of cross-border insolvency. It provides a roadmap for courts and practitioners to determine the applicable law, recognize foreign proceedings, and ensure the fair and efficient resolution of cross-border insolvency cases. Instruments like the UNCITRAL model law and the EU insolvency regulation have significantly harmonized the approach to cross-border insolvency. However, challenges remain in terms of wider adoption, consistent interpretation, and practical implementation. Understanding the intricacies of private international law in insolvency is crucial for businesses and individuals engaged in cross-border transactions. Seeking expert advice and staying informed about developments in this field can help mitigate risks, protect assets, and navigate the complexities of the global marketplace. Thank you for joining us on this journey through the labyrinth of international insolvency law. We encourage you to share your thoughts, comments, and questions below. Your engagement helps us foster a greater understanding of this critical area of law.